Hi, I'm going to do a presentation on the double Irish Dutch sandwich in regards to finance and how a lot of these issues play out. It relates to international taxation, international financing that has come to a lot of scrutiny in regards to the international tax realm. Indeed, this has caused a lot of uh, public attention on international taxation. Now, I'm going to explain it based off this photo that I have here from Wikipedia. And what this photo shows is essentially what you would expect is three countries, but also a potential fourth one that are enacting. But it can just be a paradigm that can be applied all over the place. I'm just going to explain the technical aspects of this because it relates to fair taxation and things of that nature, justice, and things like that. So basically, we're going to look at the map, but conceptually, there's going to be companies and subsidiaries and things of that nature, royalty payments, dividends, deductions, all that type of stuff coming up. And then I'll try to explain what's going on. So initially, you start off with a parent company, likely established in the United States. And then that parent company will establish a some sort of it's not exactly a subsidiary. It would be an Irish holding company that is a tax resident in Bermuda. The way this works is that the company would incorporate in Ireland but have its managers in Bermuda or the Caymans, places like that. Now, if that doesn't make sense, you can go check out one of my other videos about residents of corporate taxation, and I wrote an article in regards to that as well. But basically, Ireland has a rule that you're not a resident of of Ireland unless you have your central management and control. It goes back to the De Beers decision that has sort of been the rule for uh, based out of common law, so to speak, since the early 1900s. What's going on over here is basically you have a situation whereby it's neither really resident in Bermuda nor in Ireland. Or yeah, so I mean, you're kind of a transparent entity. What that means is the other country doesn't recognize you as being subject to worldwide taxation. What that means is you're only subject to the taxes for profits in that country. Now, so you have the Irish holding company in Ireland, and then you license intellectual property to that. Or no, excuse me, you transfer intellectual property to that Irish holding company that's also a resident in Bermuda, so it's kind of resident in both. And then you 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 license sub-license the whatever the intellectual property. It's very important that it's intellectual property because a lot of companies can manipulate the price, and perhaps wrongly so, often is the case. And they put the sub license to a Dutch conduit company, which is in the Netherlands. That's why it's a double Irish Dutch sandwich. So the Dutch conduit company, it has a sub license for the IP that was transferred from the parent company in the United States, transferred to the Irish holding company, Bermuda, Cayman's kind of resident in both or neither, depending on how you look at it. And then it's sublicensed to a Dutch conduit. The Dutch conduit sublicensed that IP to an Irish operating company that takes advantage of the check the box entity regime, which surpasses subpart F of the Internal Revenue Code that disallows controlled foreign corporations. Thereby, you're not looking at the whole of the corporations, you're just looking at what the parent company makes. So basically, we have the parent company transfers IP to the Irish holding Bermudan Cayman or Bermudan or Cayman company, and then you sublicense that IP to a Dutch conduit in the Netherlands, and then you sublicense that to an Irish operating company. Then, like over here in Germany, you have your European market. It could be anywhere. Clients' fees go to the Irish operating company. You could have group service providers where there's a cost plus agreement, and then they send fees to the Irish operating company, which then sends royalties to the Dutch Conduit Company. But the thing is that the Irish operating company is hollowed out because of all the royalty payments. That incidentally, given the European royalties directive, there's no withholding tax between Ireland and the Netherlands. Then the Netherlands has no withholding tax on royalties and interest as a side note, but it does on withholding taxes. But anyway, on dividends. But we're just having royalties here, and then you hollow out the Dutch conduit by getting all these deductions for sending royalties to the half Bermudan, half Irish company, and then dividends are deferred between the United States and the Irish holding company. And what they can do is they can send out loans from the Irish holding company to other parts of the world. So basically, what you have is dividends, deferred indefinitely, and then they're sent out as loans, and then you can hollow out the Bermudan company by interest deduction. So this is the double Irish Dutch sandwich.